Covenants, conditions, and restrictions. Those are kind of self-imposed, meaning not government-imposed restrictions on the use of private land.
All right, a little unique episode here. I'm with Tiff. We got a question. Someone called in, left a message for us, and we're going to answer it right here. So, Tiff, here's your question from one of our friendly agents right down the road.
I have a question. So, I have a client looking at a property on the lake. CC&Rs were done back in the 1980s. And it says you cannot have a detached garage. So my client wants to know, is there a way to get the CC&Rs removed? And the people who signed the CC&Rs are not living in that neighborhood anymore. So they want to know, is there a way to get the CC&Rs removed or get them changed so that they can have a detached garage?
Thank you, Ashley, for submitting that. That was a really good question. I answered that one quite a bit. That's,
Before we jump into answering it, let's go back even further and let's get really basic in case someone's not an agent that deals with this all the time. Maybe they're just someone that's interested in real estate. Maybe they want to become an agent. What is CC&R?
Yeah. Covenants, conditions, and restrictions. Or, a lot of people just call them restrictions. And those are kind of self-imposed, meaning not government-imposed, restrictions on the use of private land. So that can be anything to do with the size of your house to whether you can have chickens.
Yeah, and it can also be like in historic districts, they have CC&Rs, which would be like, you have to have this specific color of stone. You have to use this specific style of brick. So there could be restrictions on like the type of thing you're using to build your house. Like Tiff said, the size, all that kind of stuff too. But they could even restrict colors. Like you don't know. I'm sure you've seen some crazy ones where they restrict a lot of different things. But why would someone put these restrictions in place? Why would they do a self-imposed, not allowed to do things?
Well, though it sounds kind of counterintuitive, it has to do with property rights and the right to do with your land what you want. And you got to remember the people that are imposing the restrictions at the time, that was their land and that's what they wanted. So we see this a lot with people who have family land and developers are coming in and they don't want developers on their family land. So they impose restrictions about density or shall not be used for single family resident or whatever it may be. And it's to make their desires as the current owners of the property known and to make it binding.
How do you put these restrictions in play? How would I, like we have a house, obviously we're in a neighborhood, but let's say we were just on a plot of land and we want to impose some CC&Rs on our land.
Yeah. So you could do it a couple ways. One, they can be conveyed within the deed, or if like you propose, you're the owner of the property and you want to create your own CC&Rs affecting your property, and you'd record those restrictions in the Register of Deeds with a reference to the legal description of your property. So it doesn't have to, they can be extremely complicated, but it doesn't have to be.
And who can do these? It has to be the person that owns the land and is on the record with the Register of Deeds?
So yes, but sometimes there are other people that have to sign too. So that depends on if you're in a neighborhood and you've got something called a declarant. There may be a requirement that the declarant sign even if they don't own any property anymore. But at minimum, the person who owns the property has to be the one to sign them originally. Then what happens after that is dependent upon what's contained within the restrictions.
All right, so let's help out Ashley here. So restrictions made back in the day, and these people are not around anymore. So usually what happens is you go up to the person that has the restriction, but hey, Sally Sue, you have this back here about I can't have a detached garage. This is the plans that we want to put on our property. It's detached, but it's beautiful. It's a 3-car garage. It's going to make the values of our properties go up. Could you sign off for me to get this? They sign it, you move on. Well, these people aren't around.
Yeah.
What can they do?
So I want to address a couple things about that. whatever you sign has to be releasing the restrictions in accordance with the terms of the restrictions and also recorded in the Register of Deeds. I've seen people get a letter from somebody saying, look, they say they don't care anymore, but it's not in recordable form. It doesn't, it doesn't meet all the formalities. But, you know, in this case, talking about Ashley's situation, how do you remove existing CC&Rs where the people don't live in the neighborhood anymore, or maybe not living? So the same way you remove them if they are in the neighborhood is by that written instrument. So, you know, if it's very simple, you know, landowner to landowner, I, Tiffany, am conveying my 1 acre unencumbered, no restrictions lot to you, Ryan, but I'm saying you cannot have goats out there. You know, that one's a simpler thing because you go back to Tiffany, if I'm living, to get those restrictions terminated and released and notarized, recorded. That's a simple one. But now, what if I am dead? Then you go to my heirs, and they have to execute the document. It all goes back to the document, but depending on the scenario, who has to sign it. So, you know, if it gets to a point where there's nobody,
like
living,
what if person's dead or they moved across the country, can't get a hold of them, in jail, like all these crazy things have happened before. Kids or heirs or whoever it may be won't even like accept your phone call, won't even acknowledge that it's a thing.
In a lot of the things you described, you're out of luck, unless you go to court to try to get a declaratory judgment, you know, quieting title to remove the restriction. But absent death or incapacity, the grantor is the one you've got to go to. So if they're living, that's who you need. Now, that is assuming the scenario that I described where it's me conveying to you and it's just this one lot and it's one restriction on one lot. That changes when you're in a planned unit development like we live in. We live in a neighborhood and it's got all these lots and it's platted and the whole subdivision is subject to the same restrictions. Then the answer to that question is contained within the documents themselves. You know, that they'll say, oh, well, maybe an amendment can be approved after a vote of 66% of the lot owners. And then the only person that needs to sign it is the president of the board and the declarant. You know, that might be. Another scenario could be you need unanimous approval of all the lot owners to change the restrictions, and all of them have to sign. So there is not a one-size-fits-all. It's all situation dependent on the restriction that you're trying to get removed.
So step 1 for Ashley is to find the CC&Rs.
Yeah.
And figure out, is this a lot of things as far as like, is there multiple properties that are involved, or is this just a single on this individual property? Once she finds that, she needs to figure out who is the people. Are they living? And then reach out to them or whoever is in charge of it and ask.
Yeah.
And then get it registered.
Another thing that we get about this a lot is like, well, aren't they expired by now? Some expire. It'll say that within the document if they do. There has been a North Carolina Supreme Court decision, I think it was 2023, it might have been late 2022, that addressed restrictions not appearing within the chain of title within 30 years and how they may no longer apply. But that opinion was pretty narrow, and title insurers are not choosing to insure over restrictions based on that. Because, yes, that did set the tone moving forward, but the individual situations haven't been litigated enough for there to be uniformity across the state. So while that Supreme Court opinion is helpful and instructive moving forward, it is not enough to rely on for title insurance and to feel 100% confident that a restriction does not apply to your property. So we get people who are like, oh, but what about the case and this and that? So this was over 30 years ago. Well, one, it's been referenced in the chain of title in every single deed. It just doesn't apply. It's a very specific time that it might apply. And even then, it's not just a wave a magic wand type thing.